Hi, welcome to our channel of IGNOU Audiobooks. Indira Gandhi National Open University School of Sciences, SOS, Others Programs Appreciation Course on Environment, ACE, Block-3 Improving the Environment Unit-10 Environmental Legislation 10.1 Introduction. In this course so far we have covered many environmental issues such as depletion of natural resources, degradation of land, pollution of water and air, impacts of agricultural practices, industrialization, urbanization and some aspects of environmental management such as challenges of environmental management, need for sustainable development, and conservation of natural and biological resources. We have also talked about the concept of environmental quality and anti-environmental standards, which need to be maintained. As human civilization progressed, man started altering the natural environment in the pursuit of creating an economic, social and cultural environment of his own choice. This slowly resulted in the depletion of natural resources and degradation of environment. Further, with increased human population, rapid industrialization and urbanization, and developmental projects have placed a lot of strain on natural resources and also on the environment. Now situation is deteriorating so fast, especially in the last few decades, that environmental problems are posing threats to human health and to his very existence. In order to protect us and other biotic life from environmental problems and prohibition of activities affecting the environment negatively, numerous legislations have been enacted at national and international levels. In this unit, we will discuss some important environmental legislations. The coverage includes Indian legislations called acts and international legislations in the form of conventions, protocols and treaties. The success of environmental legislations mainly depends on the way they are enforced. One section of this unit is, therefore, devoted to issues involved in enforcement of environmental legislations. At the end, contribution of people through PIL, public interest litigations, and people's movement for environmental protection in the form of case studies and India's institutional arrangements for monitoring and enforcement have also been discussed. Objectives: after reading this unit, you should be able to discuss various acts enacted for the protection of environment at national level, discuss various conventions and protocols framed for global environmental issues, explain the difficulties in the enforcement of the environmental legislations, and discuss the contributions of public interest litigations, people's movements, Ministry of Environment and Forests and CPCB in protection of environment. 10. To current status. In recent past, numerous environmental problems have become critically significant for mankind. To enumerate some like air, water and land pollution, spread of toxic wastes, deforestation, mass extinction of wildlife, problem of human settlement, flood, drought and depletion of ozone layer and other natural resources. An important aspect of environmental problem is that they have intercreational repercussions, i.e., their impact is not confined to their source area alone. L1U less than spills over far and wide. Pollution does not observe political territories and legislative jurisdictions. Thus environmental problems are intrinsically global in nature. Therefore, to fight with the environmental problems we need legislation not at national level as well as at international level. 10.2.1 National legislations. At national level, serious efforts have been made for the improvement and protection of environment by changing the Constitution of India. Our Constitution, originally, did not contain any direct provision regarding the protection of natural environment. However, after the United Nations Conference on Human Environment Stockholm, the Constitution of India was amended to include protection of the environment as constitutional mandate. The Constitution, 42nd Amendment, Act of 1976 has made it fundamental duty to protect and improve the natural environment by Clause G to Article 51A It shall to be duty of every citizen of India to protect and improve the natural environment including forests, lakes, rivers and wild life and have compassion for living creatures. There is a directive given to the state as one of the directive principles of state policy regarding the protection and improvement of the environment. Article 48A states the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. The Department of Environment was established in India in 1980 to ensure a healthy environment for the country. This later became the Ministry of Environment and Forests in 1985. This ministry has overall responsibility for administering and enforcing environmental legislations and policies. The constitutional provisions are backed by a number of legislations, acts, and rules. Much of our environmental legislations are enacted as acts by the Parliament or the state legislatures. These acts generally delegate powers to regulation agencies to make rules for the purpose of their implementations. The Environment Protection Act of 1986, EPA, came into force soon after the Bhopal gas tragedy and is considered umbrella legislation as it fills many lacunae in the existing environmental legislations. Thereafter, a large number of environmental legislations came into existence as the problems began arising. For example, in recent past, the use of CNG for public transport vehicles has been made mandatory to improve the air pollution problem of Delhi. Existing Indian environmental legislations can be grouped in following four categories: A. Water Acts, B. Air Acts, C. Forest and Wildlife Acts, D. General Acts. To provide an overview of environmental legislations, a few important legislations of each category with brief description are given below. A. Veta Acts. The Green Revolution and rapid industrialization and urbanization have resulted in a profound deterioration of India's water quality. To provide legislative support for prevention of water pollution, Parliament passed India's first major water legislation, called the Water Protection and Control of Pollution Act, 1974. Some legislative provision for water pollution is also made in the Environmental Protection Act, 1986. Some important provision of the Water Act, 1974 and Amendment, 1988 are given below. The Water Prevention and Control of Pollution Act of 1974 and Amendment 1988. The main objective of this act is to provide for the prevention and control of water pollution and maintaining or restoring of wholesomeness of water in the streams or well or on land. Some important provisions of this act are given below. The Act vests regulatory authority in state boards and empowers these boards to establish and enforce effluent standards for factories discharging pollutants into bodies of water. A central board performs the same functions for union territories and coordinates activities among the states. Either boards control sewage and industrial effluent discharges by approving, rejecting or conditioning applications for consent to discharge. The state boards also minimize water pollution by advising state governments on appropriate sites for new industry. Act granted power to the board to ensure compliance with the Act by including the power of entry for examination, AF equipment and other purposes and power to take the sample for the purpose of analysis of water from any stream or well or sample of any sewage or trade effluents. Prior to its amendment in 1988, enforcement under the Water Act was achieved through criminal prosecutions initiated by the boards, and through applications to magistrates for injunctions to restrain polluters. The 198.8 Amendment strengthened the Act's implementation provisions. Now, a board may close a defaulting industrial plant or withdraw its supply of power or water by an administrative order. The penalties are more stringent, and a citizen's suit provision supports the enforcement machinery. The Water, Prevention and Control of Pollution Cess Act of 1977. The Water Cess Act was passed to help meet the expenses of the central and state water boards. The Act creates economic incentives for pollution control and requires local authorities and certain designated industries to pay a cess tax for water consumption. These revenues are used to implement the Water Act. The central government, after deducting the expenses of collection, pays the central board and the states such sums as it deems necessary to enforce the provisions of the Water Act. To encourage capital investment in pollution control, the Act gives a polluter a 70% rebate of the applicable cess upon installing effluent treatment equipment. B. Air Acts to provide legislative support for prevention and control of air pollution. The Government of India enacted a I called the Air, Prevention and Control of Pollution Act 198,1 N, referred to as Air Act 1981. The Act aims at prevention, control and reduction of air pollution. Beside this, Environmental Protection Act 1986 also covers some aspects of air pollution. Some details of the Air Act 1981 and Amendment 1987 is given below. The Air, Prevention and Control of Pollution Act of /981 and Amendment 1987 to implement the decisions taken at the United Nations Conference on the Human Environment held at Stockholm in June 1972. Parliament enacted the Nationwide Air Act. The main objectives of this act are to improve the quality of air and to prevent, control and abate air pollution in the country. Important provisions of this act are given below. The Air Act's framework is similar to the one created by its predecessor, the Water Act of 1974. To enable an integrated approach to environmental problems, the Air Act expanded the authority of the central and state boards established under the Water Act to include air pollution control. States not having water pollution boards were required to set up air pollution boards. Under the Air Act, all industries operating within designated air pollution control areas must obtain a consent permit from the state boards. The states are required to prescribe emission standards for industry and automobiles after consulting the central board and noting its ambient air quality standards. Act granted power to the board to ensure compliance with the Act include the power of entry for examination, testing of equipment and other purposes and power to take the sample for the purpose of analysis of air or emission from any chimney, fly ash or dust or any other outlet in such manner as may be prescribed. Prior to its amendment in 1987, the Air Act was enforced through mild court-administered penalties on violations. The 1987 amendment strengthened the enforcement machinery and introduced stiffer penalties. Now, the boards may close down a defaulting industrial plant or may stop its supply of electricity or water. A board may also apply to court to restrain emissions that exceed prescribed limits. Notably, the 1987 amendment introduced a citizen's suit provision into the Air Act and extended the Act to include noise pollution. C. Forest and Wildlife Acts. India is one of the few countries which had a forest policy since 1894. To protect forest and wildlife, following legislations have been enacted. The Wildlife Protection Act of 1 to 2 and Amendment 1982. In 1972, Parliament enacted the Wildlife Act Protection Act. The Wildlife Act provides for state wildlife advisory boards, regulations for hunting wild animals and birds, establishment of sanctuaries and national parks, regulations for trade in wild animals, animal products and trophies, and judicially imposed penalties for violating the Act. Harming endangered species listed in Schedule 1 of the Act is prohibited throughout India. Hunting species, like those requiring special protection, Schedule E, big game, Schedule L, and small game, Schedule 4 is regulated through licensing. A few species classified as vermin, Schedule V, may be hunted without restrictions. Wildlife wardens and their staff administer the Act. An amendment to the Act in 1982 introduced a provision permitting the capture and transportation of wild animals for the scientific management of animal population. India is a signatory to the Convention of International Trade in Endangered Species of Fauna and Flora, CITES, 1976. Under this, export or import of endangered species and their products are governed by the conditions and stipulations laid down therein. Indian government has also started some conservation projects for individual endangered species like Hungal, 1970, lion, 1972, tiger, 1973, crocodiles, 1974, and brown-antlered deer, 1981, elephant, 1991-92. The Forest Conservation Act of 1980 First Forest Act was enacted in 1927. This is one of the many surviving colonial legislations. It was enacted to consolidate the law related to forest, the transit of forest produce and the duty leviable on timber and other forest produce. Subsequently, the Forest Conservation Act was promulgated in 1980 to make certain reforms over the preceding Act of 1927. The 1927 Act deals with the four categories of the forests, namely reserved forests, village forests, protected forests and private forests. A state may declare forestlands or wastelands as reserved forest and may sell the produce from these forests. Any unauthorized felling of trees, quarrying, grazing and hunting in reserved forests is punishable with a fine or imprisonment, or both. Reserved forests assigned to a village community is called village forests. The state governments are empowered to designate protected forests and may prohibit the felling of trees, quarrying and the removal of forest produce from these forests. The preservation of protected forests is enforced through rules, licenses and criminal prosecutions. Forest officers and their staff administer the Forest Act. Alarmed at India's rapid deforestation and resulting environmental degradation, centre government enacted the Forest Conservation Act in 1980. Under the provisions of this Act, prior approval of the centre government is required for diversion of forestlands for non-forest purposes. An advisory committee constituted under the Act advises the centre on these approvals. Biodiversity Act 2000. India is one of the 12 mega biodiversity countries of the world and became a party to the International Convention on Biological Diversity in 1994. The objectives of the convention are the conservation of biological diversity, the sustainable use of its component, and the fair and equitable sharing of the benefits arising out of the utilization of genetic resources. Following this, a national policy and action strategy on biodiversity, which seek to consolidate the ongoing efforts of conservation and sustainable use of biological diversity and to establish a policy and program regime for the purpose, released by the government on May 2000. To achieve these goals, Biodiversity Bill 2000 was introduced in Parliament in May 2000. This has been finally passed only in December 2002. This bill seeks to check biopiracy, protect biological diversity and local growers through a three-tier structure of central and state boards and local committees. These will regulate access to plant and animal genetic resources and share the benefits. The proposed Nation Biodiversity Authority (NBA) will deal with all cases of access by foreigners. Its approval will be required before obtaining any intellectual property right on an invention based on a biological resource from India, or on its traditional knowledge. It will oppose such rights given in other countries. The NBA will enjoy the power of a civil court. In addition, Centre may issue directives to state if it feels a naturally rich area is threatened by overuse, abuse or neglect. D. General Acts. The most important legislation in this category is the Environment Protection Act of 1986. Through this act, central government gets full power for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating pollution. Details of this act are given below. The Environment Protection Act of 1986. In the wake of the Bhopal tragedy, the Government of India enacted the Environment Protection Act of 1986. The purpose of the Act is to implement the decisions of the United Nations Conference on the Human Environment of 1972, insofar as they relate to the protection and improvement of the human environment and the prevention of hazards to human beings, other living creatures, plants and property. The Act is an umbrella legislation designed to provide a framework for central government coordination of the activity of various central and state authorities established under previous acts, as the Water Act and the Air Act. In this Act, main emphasis is given to environment defined to include water, air and land and the interrelationships which exist among water, air and land, and human beings and other living creatures, plants, microorganisms and property. Environmental pollution is the presence of pollutant, defined as any solid, liquid, or gas substance present in such a concentration as may be or may tend to be injurious to the environment. Hazardous substances include any substance or preparation which may cause harm to human beings, other living creatures, plants, microorganisms, property or the environment. The main provisions of this Act are given below. Section 3(1) of the Act empowers the Centre to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating environmental pollution. Specifically, the central government is authorized to set new national standards for the quality of the environment, ambient standards as well as standards for controlling emissions and effluent discharges, to regulate industrial locations, to prescribe procedures for managing hazardous substances, to establish safeguards preventing accidents, and to collect and dismantle information regarding environmental pollution. By virtue of this Act, central government has armed itself with considerable powers which include coordination of action by state, planning and execution of nationwide programs, laying down environmental quality standards, especially those governing emission or discharge of environmental pollutants, placing restriction on the location of industries and so on. Powers claimed are indeed comprehensive. The coverage includes handling of hazardous substances, prevention of environmental accidents, inspection of polluting units, research, establishment of laboratories, dissemination of information, etc. The Environment Protection Act was the first environmental legislation to give the central government authority to issue direct orders, included orders to close, prohibit or regulate any industry, operation or process or to stop or regulate the supply of electricity, water or any other service. Other power granted to the central government was to ensure compliance with the Act included the power of entry for examination, testing of equipment and other purposes and power to analyze the sample of air, water, soil or any other substance from any place. The Act explicitly prohibits discharges of environmental pollutants in excess of prescribed regulatory standards. There is also a specific prohibition against handling hazardous substances except in compliance with regulatory procedures and standards. Persons responsible for discharges of pollutants in excess of prescribed standards must prevent or mitigate the pollution and must also report the governmental authorities. The Act provides provision for penalties. Any person who failed to comply with or any of the provisions of the Act, or the rules, orders, or directions issued under the Act shall be punished, for each failure or contravention, with a prison term up to 5 years or fine up to Rs. 1 lakh, or both. The Act imposed an additional fine of up to Rs. 5,000 for every day of continuing violation, if a failure or contravention occurs for more than 1 year after the date of conviction. An offender may be punished with imprisonment term, which may be extended to 7 years. The Environment Protection Act contains significant innovations for its enforcement, not contained in any other pollution control legislation at the time of the Act's adoption. Section 19 provides that any person, in addition to authorized government officials, may file a complaint with a court alleging an offense under the Act. This citizen suit provision requires that the person has to give notice of not less than 60 days of the alleged offense of pollution to the central government or the competent authority. Under the Act, the central government may, by notification in the Office Gazette, make rules for the enforcement of the Act. It is worth mentioning the names of few important rules, which have been notified under the Environment Protection Act, 1986 in recent past for the management and control of hazardous substances, which include hazardous chemicals, waste and microorganisms. I. Hazardous Waste, Management and Handling, Rules of 1989. Objective is to control generation, collection, treatment, import, storage, and handling of hazardous waste. 2. The manufacture, storage and import of hazardous chemical rules of 1989 defines the terms used in this context and sets up an authority to inspect once a year the industrial activity connected with hazardous chemicals and storage facilities. 3. The manufacture, use, import, export and storage of hazardous microorganisms/genetically engineered organisms or cells rules of 1989. These were introduced with a view to protect the environment, nature and health, in connection with the application of gene technology and microorganisms. 4. Biomedical waste, management and handling, rules of 1998. It is a legal binding on the healthcare institutions to streamline the process of proper handling of hospital waste such as its segregation, disposal, collection and treatment. 5. Recycled plastic manufacture and usage rules of 1999 and recycled plastic manufacture and usage amendment rules of 2002 rules were introduced to prohibit the usage of carry bags or containers made of recycled plastic for foodstuffs. Rules also lay down procedures for the manufacture of virgin and recycled plastic carry bags and recycled plastic containers. 6. Municipal solid wastes, management and handling, rules, 2000. According to these rules, any municipal solid waste generated in a city or a town shall be managed and handled in accordance with the compliance criteria and the procedure laid down in schedules of these rules. The waste processing and disposal facilities to be set up by the municipal authority on their own or through an operator of a facility shall meet the specifications and standards as specified in schedules. The Factories Act, 1948 and Amendment, 1987. The Government of India formulated Factory Act in 1948 to safeguard the service conditions of the workers in the factory. Shortly after the Bhopal tragedy and the Supreme Court's judgment in the Shri Ram gas leak case, the 1987 amendment to this Factories Act introduced special provisions on hazardous industrial activities. The 1987 amendment empowers the states to appoint site appraisal committees to advise on the limited location of factories using hazardous process. Factory inspector and the local authority prepare all particulars regarding health hazards at the factory, and the preventive measures taken. Then, preventive measures must be publicized among emergency disaster control plan, which must be approved by the chief inspector. The occupier is required to maintain workers' medical records and must employ operations and maintenance personnel who are experienced in handling hazardous substances. The permissible limits of exposure to toxic substances prescribed in the record schedule to the Act. Safety committees consisting of workers and managers are required periodically to review the factory safety measures. The Factories Act, after its 1987 amendment, defines occupier as a very senior level manager. Such person is held responsible relating to hazardous process. Non-compliance exposes the occupier to stiff penalties. National Environmental Tribunal Act of 1995. This has been created to award compensation for damages to persons, property and the environment arising from any activity involving hazardous substances. 10.2 International legislations. Similar to national legislations, there is no international legislation body with authority to pass legislations, nor are there international agencies with power to regulate resources in a global scale. There is an international court at Hague, the Netherlands, but it has no power to enforce its decisions. Powerful nations can simply ignore the court. As a result, international legislation must depend on the agreement of the parties concerned. Certain issues of multinational concern are addressed by collection of policies, agreements, and treaties that are loosely called international environmental legislations. Most of the international legislations are international agreements to which nations adhere voluntarily. These agreements are generally finalized through international conventions or treaties. Nations that have agreed to be bound by the convention are known as parties. Convention provides a framework to be respected by each party, which has to adopt its own national legislation to make sure that convention is implemented at national level. To support the conventions, sometime protocols are also framed. A protocol is an international agreement that stands on its own but is linked to an existing convention. This means that the Climate Protocol shares the concerns and principles set out in the Climate Convention. It then builds on these by adding new commitments which are stronger and far more complex and detailed than those in the convention. United Nations has very important role in developing and implementing conventions. The United Nations Conference on Environment and Development, 1972. Stockholm, popularly known as the Stockholm Conference, was the first step from the United Nations to address the growing problem of environmental degradation at international level. It also gave birth to the United Nations Environment Programme, UNEP, key international environmental conventions which have been agreed since the Stockholm Conference include the Convention on International Trade in Endangered Species of Wild Fauna and Flora, 1973, the Convention for the Prevention of Marine Pollution from Land-Based Sources, 1974, the Convention on Long-Range Transboundary Air Pollution, 1979, the Convention for the Protection of the Ozone Level, 1985, and the Convention on the Control of Transboundary Movements of Hazardous Waste and Their Disposal, 1989. It was again in UN Conference on Environment and Development, UNST, also known as Earth Summit, held in Rio de Janeiro in June 1992. Many global environmental issues were taken up. The Rio Declaration on Environment and Development consists of 27 principles for guiding action on environment and development. It reaffirms and builds on the Stockholm Declaration of 1972 and is important in contributing to the development of general principles of international law. The declaration is significant to highlighting the concepts of sustainable development, the precautionary principle and the polluter pay principle. The key outcomes of this meeting were Agenda 2J. This is a comprehensive, non-binding action plan for sustainable development. The document outlines actions to address the social, Economic and Environmental Dimensions of Sustainable Development, identifies the role of major groups and outlines the ways and means for implementing the various actions. It has become clear that many of the recommendations have not been fully implemented and that the sources of funding have not sufficiently been forthcoming. The UN Commission on Sustainable Development, CSD. The UN Commission on Sustainable Development was created with the aim of promoting implementation of Agenda 21 and fostering dialogue and partnerships between government, the international community and the major groups. The Forest Principles. Following the failure to reach consensus in Rio on forests, the outcome was a non-binding set of principles. Discussions on forests have continued in the Intergovernmental Panel, New Forum, on Forests. Beside these two important international conventions were agreed at the conference. I. The Framework Convention on Climate Change, UNFCCC, and 2. The Convention on Biological Diversity, CBD. In December 2000, the United Nations General Assembly has taken a decision on the 10-year review of progress achieved by the implementation of the outcome of the United Nations on Environment and Development by organizing a summit, to be called the World Summit on Sustainable Development. It will be held on August 26, September 6, 2002, Johannesburg, South Africa. It is expected that besides being a symbolic event, it will provide the global community with an opportunity to critically assess the importance of international environmental political agreements and their benefits, success, impact, positive and negative, at a national, provincial and local level. Rio+10 provides the global community with the opportunity to take another critical look at the implementation of all that took place at Rio in 1992. Now we will take up few important conventions on some international environmental issues such as chemicals and hazardous wastes, ozone layer, climate change, biodiversity and law of the sea. Conventions on Chemicals and Hazardous Wastes. In 1982, UNEP decided to deal with the problem of growing transboundary transportation and disposal of toxic wastes after an ad hoc working group of environment experts met in Montevideo, Paraguay. In 1985, UNEP issued the Cairo Guidelines and Principles for the Environmentally Sound Management of Hazardous Wastes. In June 1987, UNEP established a draft convention on the transboundary shipment of hazardous waste and created an ad hoc working group composed of legal and technical experts. This group finally developed a recommendation for the Basel Conversation. After 2 years of intense and divisive debate on March 22, 1989, 34 nations signed the Basel Conventions. The Basel Convention on the Control of Transboundary Movement of Hazardous Wastes and Their Disposal was adopted in 1989 and enforced on 5 May 1992. The convention is considered the response of the international community to their problem caused by the annual worldwide production of 400 million tons of wastes which are hazardous to people or the environment because they are toxic, poisonous, explosive, corrosive, flammable, ecotoxic, or infectious. The main principles of the Basel Convention are: transboundary movement of hazardous waste should be reduced to a minimum consistent with their environmentally sound management. 2. Hazardous waste should be treated and disposed of as close as possible to their source of generation. 3. Hazardous waste generation should be reduced and minimized at source itself_I:_data. In order to achieve the three main principles, the convention established its Secretariat to control the transboundary movement of hazardous waste, to monitor and prevent illegal traffic, to provide assistance for the environmentally sound management of hazardous waste, to cooperate with party countries or promote cooperation between parties, and to develop technical guidelines for the management of hazardous wastes. The convention is further modified in the third meetings, and it has decided to ban exports of hazardous wastes to developing countries, on the grounds that those countries mostly have neither the expertise nor the facilities to manage such wastes. Conventions on the ozone layer. It is now generally understood that ozone is constantly created, destroyed and recreated in the upper part of the atmosphere, i.e., the stratosphere, by numerous photochemical reactions. Some chemicals such as chlorofluorocarbons, CFCs, halogens, halogenated hydrocarbons, and other gases tend to change this equilibrium. Because CFCs are particularly stable compounds, they do not break up in the lower atmosphere, i.e., the troposphere. Instead, they gradually transgress to the stratosphere where, in the presence of ultraviolet radiation, they are broken down, releasing chlorine. This free-floating chlorine acts as a catalyst and destroys ozone. Laboratory work indicates that one chlorine atom can destroy about 1 lakh ozone molecules. This destructive process has significant implications for human health and has important impacts on plants, aquatic organisms and man-made materials as ozone layer in stratosphere stop harmful ultraviolet radiations. There is now evidence that the increased ultraviolet radiation, which directly results from ozone depletion, induces certain types of skin cancer, suppresses or destroys the human immune system and causes cataracts. Many varieties of terrestrial and aquatic plants are also affected by increases in ultraviolet radiation. Further, many species of phytoplankton, which provide food for nearly all fish, are also in danger. What is more, ultraviolet radiation reaching the Earth's surface following stratospheric ozone depletion contributes, along with other forms of air pollution, to property damage such as fading paint, yellowing of window glazing and chalking of polymer automobile roofs. The United Nations Environment Programme, UNEP, has been addressing this issue since 1977. Under the auspices of UNEP, the nations of the world arrived at the Convention for the Protection of the Ozone Layer in Vienna in 1985. Through this convention, nations committed themselves to protecting the ozone layer and to cooperation with each other in scientific research to improve understanding of the atmospheric processes and serious consequences of ozone depletion. The convention provided for future protocols and specified procedures for amendment and dispute settlement. To pursuant the objectives of Convention for the Protection of Ozone Layer, the Montreal Protocol on Substances that Deplete the Ozone Layer was agreed to by nations in 1987 and has since been amended 5 times so far. Its control provisions were strengthened through 5 amendments to the protocol adopted in London, 1990, Copenhagen, 1992, Vienna 1995, Montreal, 1997, and Beijing, 1999. The protocol aims to reduce and eventually eliminate the emission of man-made ozone-depleting substances. The Vienna Convention and Montreal Protocol are considered a highly effective regime for reducing, and possibly, in the future, eliminating emissions of ozone layer depleting chemicals. Unlike most environmental agreements, the Montreal Protocol contains economic incentives to encourage participation and compliance. The parties have agreed to establish a working group to develop recommendations concerning the determination and consequences of non-compliance. The Montreal Protocol uses 3 kinds of provisions as economic incentives to encourage participation and compliance with the protocol's control regime. 1. Entry into force requirements. 2. Controls on trade with non-parties. And 3. Research and technology transfer. Benefits. The Montreal Protocol provides in its Article 16 that 11 countries, representing two-thirds of global consumption of controlled substances, must ratify the protocol before it may enter into force. Thus, the protocol creates a cartel of consumers who control the consumption market and who have agreed to reduce their consumption. The Montreal Protocol also provides a gradual ban on trade with non-parties. The protocol promotes technology transfer to developing countries, thereby offering economic incentives for developing countries to join and comply. Conventions on climate change. Global warming, greenhouse effect, is probably the greatest threat to the future of the planet. It is mainly caused by gases like carbon dioxide, water vapors, methane, nitrous oxide, CFCs, emitted by industrialized countries on the burning of fossil fuels, coal, oil and gas, for electricity, heating and transport. Because of gases that have been emitted in the past and are still pouring into the atmosphere, it is already too late to prevent some climate change. However, if we start reducing emissions now, we may be able to avoid some of the worst effects. Today, action occurs at every level to produce, to avoid, and to understand the risks associated with climate change. Many nations have prepared national plans and are actively pursuing programs and policies that will result in green gas emission reduction. At the global level, countries around the world have expressed a firm commitment to strengthening international responses to the risks of climate change and strengthening international action and broader participation under the auspices of the UN Framework Convention on Climate Change, UNFCCC. UN Framework Convention on Climate Change is the landmark international treaty unveiled at the United Nations Conference on Environment and Development in Rio de Janeiro in June 1992. The UNFCCC commits signatory countries to anthropogenic, i.e., human-induced, greenhouse gas emissions to levels that would prevent dangerous anthropogenic interference with the climate system. Such a level should be achieved within a time frame sufficient to allow ecosystems to adapt naturally to climate change, to ensure the food production is not threatened and to enable economic development to proceed in a sustainable manner. To pursue the objectives of the Convention on Climate Change, the Kyoto Protocol was agreed by the nations of the world in December 1997 in Kyoto, Japan. The protocol states that Annex I nations, mostly developed countries, are committed, individually or jointly, to ensuring that their aggregated anthropogenic carbon dioxide equivalent emissions of greenhouse gases do not exceed amount assigned to each country in Annex B to the protocol, with a view to reducing their overall emissions of such gases by at least 5% below 1990 levels in the commitment period 2008 to 2012. Annex A lists the 6 major greenhouse gases covered by the treaty: carbon dioxide, COS, methane, CH4, nitrous oxide, azo, hydrofluorocarbons, HFCs, perfluorocarbons, PFCs, and sulfur hexafluoride, SF6. Annex B lists 39 nations, including USA, the European Union plus individual EU nations, Japan, and many of the former communist nations. The amount of each nation are listed as percentage of the base year, 1990, and range from 92%, a reduction of 8%, for most European countries to 110%, an increase of 10%, for Iceland. The USA has committed on this list to 93%, or a reduction of 7%, to be achieved as an average over 5 years 2008 to 2012. The protocol does call on all parties, developed nations and developing nations, to take a number of steps to formulate national and regional programs to improve ILOCA emission factors, activity data, models, and national inventories of greenhouse gas emissions and sinks that remove these gases from the atmosphere. All parties are also committed to formulate, publish and update climate change mitigation and adoption measures, and to cooperate in promotion and transfer of environmentally sound techniques and in scientific and technical research on the climate system. Recently, the progress of Convention on Climate Change and Kyoto Protocol was reviewed in 8th session of the Conference of the Parties to the Climate Change Convention, 8 Colombian pesos, held in New Delhi on 23 October to 1 November 2002. It was attended by 5,000 participants from 170 countries and numerous organizations. Indian Prime Minister Atal Bihari Vajpayee addressed the meeting. The government of Italy from 12 December 2003 will host COP9 Conventions on Biodiversity. Although not formally part of the UN's preparatory process, the Rio Summit provided political impetus for completing the negotiations on the Convention on Biological Diversity, CBD. This was not part of the formal UN's process, but was an important parallel outcome. The aim of the CBD is to promote the conservation and sustainable use of biodiversity through commitments relating, for example, to promoting scientific and technological cooperation, establishing protected areas, eradicating alien species, respecting and maintaining traditional knowledge and practices, and providing financial resources. In January 2000, the Cartagena Biosafety Protocol was adopted to address potential risks associated with cross-border trade and accidental releases of living modified organisms. It is hoped that this protocol will be ratified at the Johannesburg Summit 2002. Conventions on Law of the Sea. After the Second World War, the increasing complexity and myriad interpretations of the global rules for ocean use encouraged efforts to standardize international legislation of the sea. The most important multilateral negotiations in this regard were the first United Nations Convention on the Law of the Sea, UNCLOS I, 1958, the Second United Nations Convention on the Law of the Sea, UNCLOS XI, 1960, the Third United Nations Convention on the Law of the Sea, UNCLOS I, 1967, and Convention on the Prevention of Marine Pollution by Dumping of Wastes and Other Matter, London Convention, 1972. Attempts have been made through the years to regulate the use of the oceans in a single convention that is acceptable to all nations. This effort finally culminated with the adoption of the 1982 United Nations Convention on the Law of the Sea, LOSC, which has gained nearly universal acceptance since its entry into force on the 16th of November 1994. The 1982 United Nations Convention on the Law of the Sea provides, for the first time, a universal legal framework for the rational management of marine resources and their conservation for future generations. Rarely has such radical change been achieved peacefully, by consensus of the world community. It has thus been hailed as the most important international achievement since the approval of the United Nations Charter in 1945. The United Nations Convention on the Law of the Sea lays down a comprehensive regime of law and order in the world's oceans and seas, establishing rules governing all uses of the oceans and their resources. It enshrines the notion that all problems of ocean space are closely interrelated and need to be addressed as a whole. The convention also provided the framework for further development of specific areas of the law of the sea. Some of the key features of the convention are the following. Coastal states exercise sovereignty over their territorial sea, which they have the right to establish its breadth up to a limit not to exceed 12 nautical miles. Foreign vessels are allowed innocent passage through those waters. Ships and aircraft of all countries are allowed transit passage through straits used for international navigation. States bordering the straits can regulate navigational and other aspects of passage. Archipelagic states, made up of a group or groups of closely related islands and interconnecting waters, have sovereignty over a sea area enclosed by straight lines drawn between the outermost points of the islands. All other states enjoy the right of archipelagic passage through such designated sea lanes. Coastal states have sovereign rights in a 200 nautical mile exclusive economic zone, EEZ, with respect to natural resources and certain economic activities, and exercise jurisdiction over marine science research and environmental protection. All other states have freedom of navigation and overflight in the EEZ, as well as freedom to lay submarine cables and pipelines. Landlocked and geographically disadvantaged states have the right to participate on an equitable basis in exploitation of an appropriate part of the surplus of the living resources of the EEZs of coastal states of the same region or sub-region. Highly migratory species of fish and marine mammals are accorded special protection. Coastal states have sovereign rights over the continental shelf, the national area of the seabed, for exploring and exploiting it. The shelf can extend at least 200 nautical miles from the shore, and more under specified circumstances. Coastal states share with the international community part of the revenue derived from exploiting resources from any part of their shelf beyond 200 miles. The Commission on the Limits of the Continental Shelf shall make recommendations to states on the shelf's outer boundaries when it extends beyond 200 miles. States enjoy the traditional freedom of navigation, overflight, scientific research and fishing on the high seas. They are obliged to adopt or cooperate with other states in adopting measures to manage and conserve living resources. The limits of the territorial sea, the exclusive economic zone and continental shelf of islands are determined in accordance with rules applicable to land territory. But rocks which could not sustain human habitation or economic life of their own would have no economic zone or continental shelf. States bordering enclosed or semi-enclosed seas are expected to cooperate in managing living resources, environmental and research policies and activities. Landlocked states have the right of access to and from the sea and enjoy freedom of transit through the territory of transit states. States are bound to prevent and control marine pollution and are liable for damage caused by violation of their international obligations to combat such pollution. All marine scientific research in the EEZ and on the continental should be subject to the consent of the coastal state, but in most cases they are obliged to grant consent to other states when the research is to be conducted for peaceful purposes and fulfills specified criteria. States are bound to promote the development and transfer of marine technology on fair and reasonable terms and conditions, with proper regard for all legitimate interests. States parties are obliged to settle by peaceful means their disputes concerning the interpretation or application of the Convention. Disputes can be submitted to the International Tribunal for the Law of the Sea established under the Convention, to the International Court of Justice, or to arbitration. Conciliation is also available and, in certain circumstances, submission to it would be compulsory. The tribunal has exclusive jurisdiction over deep seabed mining disputes. Agenda 21, Chapter 17. In 1992, the United Nations Conference on Environment and Development, UNCED, held at Rio de Janeiro adopted a declaration and a global agenda for management of the environment into the next century, Agenda 21. The UNCED process classified several important concepts of environmental management that have immediate relevance to the marine environment. Indeed, Chapter 17 of Agenda 21 emphasizes these general principles in its discussion of the oceans. Some important environmental concepts to be legitimized by UNCED are the ideas of ecologically sustainable development, ESD, the precautionary approach, and integrated oceans management. The combined effect of conventions on law of sea and UN's Agenda 21. Chapter 17 proven to be a far and unprecedented level of activity around the world as various countries strive to develop and articulate their oceans policy. 10.3 Issues in enforcement. In the earlier section of this unit you have learnt about various environmental acts at national level and environmental legislations at international level. Now we will take up the issues involved in their enforcement. 10.3.1 Problems and Prospects. You must be aware that despite so many legislative measures, the state of the environment in India continues to be gloomy. The rivers and the lakes continue to be polluted with sewage and industrial waste. Bioresources continue to disappear. The air quality in some major cities is at alarming stage. According to the World Health Organization, at present the capital city of New Delhi is one of the top 10 most polluted cities in the world. Surveys indicate that in New Delhi the incidence of respiratory diseases due to air pollution is about 12 times the national average. All these situations force us to know the answers of following questions. Where are the problems? What can be done to reverse the process and restore a balanced state of the environment? Let us first identify the basic problems in enforcement of national environment legislations. After an analysis of all enactments and provisions at national level, it is to be noted that nature of most of the existing environmental legislations are essentially punitive, not preventive. Only once the chemicals or substances are discharged into the air or water or soil does the act apply. The preventive measures have hardly ever evoked or worked, and the concerned agencies have moved into action only after the harm has been done. If we are serious in enforcement of environmental legislations, we have to stop this fire brigade approach, rushing to the spot of fire after it break out. The strategy should lay equal emphasis on attacking the cause of fires. An ounce of prevention in the field of environment is literally worth a gallon. More serious problem in the implementation of environmental legislation is overlapping powers of authorities involved in supervising the safety mechanism and devices of companies, and in granting or refusing no objection certificate (NOC). Thus, though the Water and Air Pollution Board may refuse to grant NOC, the municipality may grant a license to an industrial unit based on which it may start its manufacturing activity. In some cases, statutes of environmental legislations do not lay down any guidelines on the nature of the authority and their specific rights and the obligations. In the absence of statutory guidelines, the agencies can be structurally inexpert, functionally inefficient, and thus totally ineffective. It is also possible that Act is passed long time back but rules are not framed for enforcement and prosecution. In the absence of such rules, it becomes very difficult for the environmental agencies to take any action against defaulters. In recent past, Delhi state government has banned the manufacture and use of colored plastic bags, without formulating the rule to prosecute defaulters. So when the State Environment Department found some factories manufacturing the banned bags, it has little clue on what action to take. Sometimes casual attitude of enforcement agencies also affects the enforcement of the legislations. This can be illustrated by taking an example of National Environmental Tribunal Act, 1995. This legislation was passed 7 years ago for delivering speedy justice to those suffering from accidents involving hazardous substances. But the fact is that the Environmental Ministry has not yet been able to find a suitable officer to head it. This is a gross display of apathetic attitude of environmental agencies. A common feature with environmental legislation in India is that they exclude people's participation in their implementation. The enterprises, which make profits at the expense of the environment, are always well represented and their interests well protected, but not those of the common person who suffer the consequences of pollution and degradation. Sometimes enforcement of legislation is difficult due to shortage of funds. Take for example the rivers pollution in India. It is well known that the major source of pollution of rivers is domestic sewage, which municipalities nonchalantly dump in the nearest rivers. 90% of the pollution of Ganga stream from the 100-odd untreated municipal waste dumping. The colossal cleaning up operation, Ganga Action Plan, will be an exercise in futility if it is not accompanied by a massive effort to prevent the municipalities from dumping their wastes in the river. Everyone knows that the technology for treating municipal wastes exists, but it's cost many and most of the municipalities cannot afford it. Public opposition also makes difficult the implementation of environmental legislation. For example, India Supreme Court recently made mandatory the use of CNG for all public transport vehicles in New Delhi. This ruling, however, led to the disappearance of some 15,000 taxis and 10,000 buses from the city, creating public protests, riots, and widespread commuter chaos. Similarly, public did not support the order of Supreme Court regarding ban on all public vehicles that were more than 15 years old. Thus we can conclude that the Environmental Act is being designed as a watchdog guarding society against pollution. But the question is, to what extent have these legislations, together with the pollution boards, succeeded in improving the quality of human life? The record of their ineffectiveness is far more voluminous than that of their success. Soon after the Bhopal tragedy, a series of gas explosions, chemical accidents and leakages occurred in many parts of the country. Nevertheless, despite the existing inadequacy of legislations and the complexity of judicial procedures, some new decisions of the court in recent past have generated a hope that with the passage of these enactments, environmental protection will be controlled to some extent in the country, and that the offending companies' agencies will be brought to book by streamlining the enforcement agencies. This is possible if the enforcement machinery and agencies function properly along with public support. Nowadays, judiciary is playing a vital role in the growth and development of environmental precedents. As a watchdog, it strives to maintain the sanctity and dignity of the Constitution so that it may not remain a mere paper tiger. But these are very few examples in which people through public interest litigations, PIL, seek judiciary to enforce existing environmental legislations. For highlighting the contribution of PILs, we are giving few notable examples. In year 2000, Supreme Court ordered to shut down polluting factories in residential areas of Delhi. This order was opposed by thousands of workers and factory owners. But this move has and will definitely safeguard the health of many residents who are living nearby to the polluting industries. Due to excess noise during the festival periods, the local ROT in Kolkata passed strict limits on noise beyond certain limits and ordered its strict enforcement. Similarly, in the capital region of Delhi, all new vehicles from June 2001 should have pollution prevention mechanism comparable to Euro EU levels, known as Bharat Stage H, prevailing in many European countries. In recent time, toes on disposal of plastics, packaging, locating and shifting of polluting industries, and common effluent treatment plants for small-scale industries and making mandatory the use of tongue in vehicles used for public transport have all become very important, and these legislations are being regularly followed by implementing authorities by the order of honorable courts. Another good example of the success of PIL is case of Taj Mahal. In this famous case, Mahesh Chandra Mehta, a prominent environment lawyer, fought for 10 years to persuade the Supreme Court to ban coal-based industries emitting effluents that damaged the soft marble of the Taj Mahal, India's architectural masterpiece. The court shut down 230 factories and directed more than 300 others near the building to install pollution control devices. For this public service, Mehta has won the 1997 Ramon Magsaysay Award. Mehta also campaigned for the introduction of lead-free gasoline in India's 4 largest cities, which has been done, and for 250 towns and cities near Ganga to install Sewage treatment plants. The Supreme Court ordered over 2,000 industries along the Ganga to clean up or close. He also won a Supreme Court decision that forced a fertilizer factory to compensate thousands of people sickened by a 1985 gas leak. Many of the legislations such as restraining the use of plastic bags can be fully enforced if public consciousness can be raised rather than await a judicial direction. After all, many environmental legislations are essentially social code of conduct that should automatically be a part of a better civic sense instead of a legal framework. Thus, public awareness and environmental education together can considerably reduce the needs for multitudes of environmental legislation, since enforcement under the Indian context will continue to be difficult in foreseeable future. As we have said earlier, that international law is different in basic concepts from domestic legislation because there is no world government with enforcement authority over all nations. As a result, international legislations must depend on the agreement of the parties concerned to bind them to less than greater than follow up the term and condition of the concerned document. But there may be a possibility that many residents of a particular nation may oppose. Because of this reason, efforts at the international level to improve environmental quality have been largely unsuccessful. There are many examples of abuse of the planet despite of hundreds of international treaties, protocols and conventions. But these international legislations certainly have played a major role in protecting many resources, restoring water quality regionally, and slowing the depletion of global resources such as the ozone layer. In next subsection we will take up few important case studies on environmental issues. 10.3.2 Case studies. Though legislations and regulations are the foundations of most environmental protection policies, the global nature of resources and pollution make international legislations and conventions essential. Public interest litigations and people's movement have also played very important role in environmental protection. In this section we will take up a few cases of and people's movement in India against environmental degradation. Taj Trapezium Zone. Problem of pollution has now become so severe that it is not only affecting human health and livestock but it is also damaging buildings and monuments. Over the past 2 decades, the fate of the India's most emblematic monument, the Taj Mahal, has repeatedly come into the spotlight because of the ill effect of the pollution caused by the iron foundries, Mathura refinery, glass factories of Firozabad and brick kiln in the Taj Trapezium Zone, TIZ. This is the area around Taj, spreading over 10,400 square kilometers. On repeated occasions, sulfur dioxide emissions from industries in this area have reached levels 10 times above the prescribed standard level. Combined with oxygen and moisture, sulfur dioxide converts to highly corrosive acid, sulfuric acid. This acid corrodes the marble, forming fungus that experts refer to as marble cancer. Blaming pollution and regulatory negligence of Taj's decay, Mahesh Chandra Mehta, a prominent environmental lawyer, filed a case before the Supreme Court of India in 1984. Mehta pleaded with the court to order the various industries to take anti-pollution measures or to close. He also stressed that pollution was affecting the health of the workers and people living in Nagara. Because of Mehta's efforts, in 1996, the Supreme Court finally ruled that the industries in the area were actively contributing to air pollution and ordered major industries units to install pollution control devices. Not even 1% chance can be taken when human life apart the preservation or a prestigious monument like the Taj is involved, stated the court order. The court ordered 292 coal-based industries to switch to natural gas or else to relocate outside the protected zone by April 30, 1997. Because of the opposition from industries and workers, court order was not enforced completely. The Supreme Court struck again in 1997, ordering the closure of 53 iron foundries and 107 other factories in Agra that have not cleaned up their acts. Recently, the Supreme Court banned cars and parking within 500 meters of the Taj's boundary walls. Experts agree that some of these measures have helped to improve air around the Taj. Chipko movement. From the last 19th century, the Himalayan forests, which are rich in softwood and pine resin, have been subject to rapid exploitation. This large-scale destruction has led to severe ecological problems, rapid soil erosion, growing frequency of floods, restrictions towards common property resource, CPR, reduction in the availability of firewood and fodder, landslides and disappearance of water table, caused concern among people. In Upper Alaknanda Valley, people have also resented the conversion of natural forests into monoculture plantations to check environmental degradation in this region. Voluntary organizations like the Gangotri Gram Swarajaya Sangh, GGSS, in Uttarakashi and the Sholi Gram Swarajaya Mandal, DGSM, in Gopeshwar started Chipko movement in the 1970s. Environmentalists like Chandi Prasad Bhatt and Sundarlal Bhaguna led the Chipko Middle Dot movement. Chipko means hug the tree. Volunteers, in their attempt to stop commercial felling, threaten to hug the trees if the saws come near them. Its activities popularized the movement through folk songs, street plays and widespread campaign. Its slogan was, "What do the forest bear? Soil, water and pure air." Soil, water and pure air are the basis of life. As a result of this struggle, the government replaced the contractor system and formed Uttar Pradesh Forest Department Corporation, UTPDC, and the forest-related activities were encouraged through local cooperatives. In 1981, as a response to Sundarlal Bahuguna's indefinite fast, the government constituted an 8-member expert committee to prepare a comprehensive report on the Himalayan forest policy. The government later put a 15-year moratorium on commercial fallings in the Uttarakhand Himalayas. Silent Valley Movement. This movement is one of the most important ecological movements in India. Silent Valley is the narrow valley of the Kunti River in the state of Kerala in the southwest of India at high elevation. Its 8,950 hectares of rainforest is rich with valuable plants and animals. In 1973, the state government of Kerala decided to build a dam across the gorge in order to generate hydroelectricity. It would have drowned valuable forest and threatened the loss of wildlife. Even the government's ecological task force expressed its dissatisfaction over the loss of forest and wildlife. By 1979, students' voluntary organization like Kerala Shastra Sahitya Parishad, KSSP, science forums, teachers, progressive citizens and journalists began to work against the project. In 1979, Save Silent Valley Committee emerged. Lobbyists like Variwa also worked for it. Dilnawaz Variawa was the coordinator of the Mumbai-based Save Silent Valley Committee in the crucial period a quarter-century ago, and instrumental in mobilizing global agencies such as the International Union for the Conservation of Nature, IUCN, which petitioned the Union government to save the valley. This hue and cry among all circles led the government headed by the then Prime Minister, Mrs. Indira Gandhi, to set up a high-level technical committee headed by Professor M.G.K. Menon and accept its recommendation that the project should not be proceeded with and that the valley should be preserved as a precious biosphere reserve. 10.3 The Narmada Bachao Andolan. The Narmada Dam project dispute is ambitious plan to build 30 large, 135 medium and 3,000 small dams to harness the waters of the Narmada and its tributaries. But this project is at the core of many controversies. Environmentalists suggest construction of large number of small dams along the river as the alternative of large dams, which can be socially and economically and environmentally sustainable. Though the dam issue may have no problem with existing environmental legislations, the social problems associated with the dam issue needs consideration outside the sphere of only legal perspectives. While the Supreme Court has given his judgment on this, 18th Act 2000 Court has allowed the construction subject to certain condition. Further, the earthquake in Gujarat Jan. 26, 2001 has reopened the hot discussion about large dams on Narmada River, though the Supreme Court had earlier cleared the dam construction subject to certain condition. 10.4 Institutional Arrangement for Monitoring and Enforcement, CPCB. The Government of India, recognizing the severity of environmental problems, in 1972 established a National Committee on Environmental Planning and Coordination, NCEP, to advise the government on environmental problems and make recommendation for their improvement. The NCEP was replaced by a National Committee of Environmental Planning, NCEP, to discharge the following functions: preparation of an annual State of Environment report for the country, establishing an environmental information and communication system to propagate environmental awareness through the mass media, to sponsor environmental research, arranging public hearing or conferences and issues of environmental significance. In 1980, the government appointed Tiwari Committee, which recommended formation of Department of Environment for ensuring environmental protection. On this basis, a full-fledged Department of Environmental created with effect from November 1, 1980 under the charge of the Prime Minister. The Department of Environment is the nodal agency in the administrative structure of the central government for planning, promotion and coordination of environmental program. Since January 1985, it forms a part of the newly created Ministry of Environment and Forests. This ministry, now, is the nodal agency for planning, promotion, coordination and supervising the implementation of the various environmental and forestry programs. The ministry has also overall responsibility for administering and enforcing environmental legislations and policies. The ministry has also been designated as the nodal agency in the country for the United Nations Environment Programme, UNEP, International Center for Integrated Mountain Development, and looks after the follow-up of the United Nations Conference on Environment and Development, UNCED. Within the overall framework of its mandate, the activities of the ministry includes conservation and survey of flora, fauna, forests and wildlife, afforestation and regeneration of degraded area, prevention and control of pollution, protection of environment, environmental impact assessment, dissemination of environmental information, eco-regeneration, assistance to organization implementing environmental and forestry programs, promotion of environmental and forestry research, extension, education and training to augment the requisite manpower, coordination with central ministries, state government, environmental policy and legislation, and international cooperation, creation of environmental awareness among all sections of the population. The ministry has many divisions, departments and boards to implement its own objectives and environmental legislation, such as Botanical Survey of India, Zoological Survey of India, National Museum of Natural History, Indian Forest Services, Central Pollution and Control Board, CPCB, Forest Survey of India, National Afforestation and Eco-Development Board, etc. In next part we will discuss the role of in environmental protection sketchily. The Central Pollution Control Board, CPCB. The Central Pollution Control Board, CPCB, was constituted in September 1974 under the provisions of the Water, Prevention and Control of Pollution Act, 1974. The main functions of CPB, as spelled out in the Water, Prevention and Control of Pollution Act, 1974, and the Air, Prevention and Control of Pollution Act, 1981, are I. To promote cleanliness of streams and wells in different areas of the states, through prevention, control and abatement of water pollution, and 2. To improve the quality of air and to prevent, control or abate air pollution in the country. The main functions of CPCB are given below. Functions of the Central Pollution Control Board: to advise the central government on any matter concerning prevention and control of water and air pollution and improvement of the quality of air, to plan and execute a nationwide program for the prevention, control or abatement of water and air pollution, to coordinate the activities of the state boards and resolve disputes among them, to provide technical assistance and guidance to the state boards, carry out and sponsor investigations and research relating to problems of water and air pollution, and for their prevention, control or abatement, to plan and organize training of persons engaged in programs on prevention, control or abatement of water and air pollution, to organize through mass media a comprehensive mass awareness program on prevention, control or abatement of water and air pollution, to collect, compile and publish technical and statistical data relating to water and air pollution and the measures devised for their effective prevention, control or abatement, to prepare manuals, codes and guidelines relating to treatment and disposal of sewage and trade effluents as well as for stack gas cleaning devices, stacks and ducts, to disseminate information in respect of matters relating to water and air pollution and their prevention and control, to lay down, modify or annul, in consultation with the state governments concerned, the standards for stream or well, and lay down standards for the quality of air, and to perform such other functions as and when prescribed by the Government of India. CPCB also functions as state board for the Union Territories. In such situation its functions are as follows: to advise the governments of Union Territories with respect to the suitability of any premises or location for carrying on any industry which is likely to pollute a stream or well or cause air pollutions, to lay down standards for treatment of sewage and trade effluents and for emissions from automobiles, industrial plants, and other polluting sources, to evolve efficient methods for disposal of sewage and trade effluents on land, to develop reliable and economically viable methods of treatment of sewage, trade effluent and air pollution control equipment, to identify any area or areas within Union Territories as air pollution control area or areas to be notified under the Air Prevention and Control of Pollution Act, 1981, and to assess the quality of ambient water and air, and inspect wastewater treatment installations, air pollution control equipment, industrial plants or manufacturing process to evaluate their performance and to take steps for the prevention, control and abatement of air and water pollution. As per the policy decision of the Government of India, the CPCB has delegated its powers and functions under the Water Prevention and Control of Pollution Act, 1974, the Water Prevention and Control of Pollution (Cess) Act, 1977 and the Air Prevention and Control of Pollution Act, 1981 with respect to Union Territories to respective local administrations. CPCB along with its counterparts, State Pollution and Control Boards, SPCBS, are responsible for implementation of legislations relating to prevention and control of environmental pollution. The CPCB advises the central government on all matters concerning the prevention and control of air, water and noise pollution and provides technical services to the Ministry for implementing the provisions of the Environmental Protection Act of 1986. Under this Act, effluent and emission standards in respect to various categories of industries have been notified. During 2001 standards for coal mines, standards for effluents from textile industries, and primary water quality criteria for bathing water have been finalized and notified in the Gazette. Board has identified 17 categories of heavily polluting industries. They are cement, thermal power plant, distilleries, sugar, fertilizer, integrated iron and steel, oil refineries, pulp and paper, petrochemicals, pesticides, tanneries, basic drugs and pharmaceuticals, dye and dye intermediates, caustic soda, zinc smelter, copper smelter and aluminium smelter. Out of total 1,551 units identified so far under these categories, 1,326 units have installed adequate facilities for pollution control, 172 units have been closed down and remaining 53 are in defaulters list. CPCB, in consultation with state boards, has also identified some critically polluted areas in the country, which need special attention for control of pollution. Action plans have been prepared and are being implemented in these areas. The CPCB, in collaboration with the SPCBs, monitor the quality of fresh water resources of the country through a network of 507 monitoring stations located all over the country. Under the National Ambient Air Quality Monitoring Program, 290 stations covering over 90 cities/towns are being monitored by the CPCB. Thank you for listening. We will be back with next chapter.